Dear students, this is my third lecture on fundamental rights. The previous two lectures we devoted on right to equality, that is our first fundamental right. And in this lecture, we will focus on the second fundamental right, that is right to freedom. It is incorporated in our Constitution Part 3 from Article 19 to 22. Part 3, as we know, deals with fundamental rights. Now, before we proceed further, I would like to mention two general observations regarding this. Number one is that absolute freedom leads to anarchism. It reminds me Hobbesian state of nature, which was ruled by law of nature, where man was nasty, brute and selfish. And apart from this, society was ruled by might is right and logic of fish prevails in the society. There was complete lawlessness in the society. There were no rules and regulations. To end this sorry state of affair, people assembled at one place and signed a contract. The contract was to formulate a civil society. Hence, a civil society was formulated to end anarchy. So, and the second observation is that I often ask my students in the class, what is the significance of 15th August 1947? They promptly reply that we got independence on that day. The more appropriate answer to this, to my perception, is that not we, India got independence on 15th August 1947, and a process to transfer power was initiated by the Britishers and the power was transferred to the Indian elected people. Hence, they were assigned the responsibility to write a constitution of their own. And that constitution granted us a right to freedom. In fact, all rights. So, two things can be drawn from this explanation. One is that civil rights and liberties and freedoms prevail in civil society only. If there is no civil society, such rights has no meaning at all. Second observation is that you need a written document to ensure your freedoms and rights. Now let us move to this particular, in the light of this introduction, let us move to Article 19, which is our current topic of discussion today. Article 19, 1 and 2. Article 19, 1 and 2 specifically mentions about the provisions of right to freedom and the exceptions. Article 19, provision 1 clearly states that all the citizens of India have a freedom of speech and expression. Now, how can you what are the mediums through which you can speak and express yourself? Number one, you can you have the right to speak. Second, if you cannot, you can express yourself by symbols, by writings, by publications, by distributing pamphlets, by films, or so many other modes of expressions are available. All of them are available to the citizens of India. Now, Article 19.2 deals with exceptions in this. What are the exceptions? Article 19.2 clearly mentions, or to simplify it more, I have decided to give this article titles. Although it is not a constitutional provision, you should note it. This is for your convenience only. The first heading you can see nature and scope of this particular article of 19.1 and 2. Now let us come to the first topic first, nature. What is the nature of Article 19? Very important thing to note down here is that it is not absolute right. You should note it. It is not absolute right. Reasonable restrictions have to be imposed. Now, the question arises that who imposes these reasonable restrictions? Obviously, reasonable restrictions are imposed by law, and laws are framed by Parliament. the central legislative assemblies. Now, who judges whether the restrictions are reasonable or not? It is always, as we know, the judiciary of India. It judges whether the restrictions imposed by the law are reasonable or not. I must remind you one very important case in this regard, that is A.K. Gopalan versus A.K. Gopalan versus State of Madras, 1951, in which court observed that man is a rational being. He has unlimited desires. His unlimited desires are controlled by the similar desires of others. It simply means that your freedoms and your rights ends where the freedoms and rights of others starts. आपकी स्वतंत्रताएं और अधिकार वहां खत्म होते हैं जहां दूसरों के अधिकार और स्वतंत्रताएं शुरू होती हैं. So 19 provision 2, I will explain few of them, the reasonable restrictions imposed by the Constitution in this regard. First is sovereignty. Sovereignty of the nation should not be compromised by the freedom of right to freedom. Now, what do we mean by sovereignty? As we know, we have been reading it since from graduation classes. Sovereignty is absolute power of the state. It lies with the nation, our country. So, how can we define this? Sovereignty is that absolute power of the state which can command all but receives command from none. So this is sovereignty should not be compromised. Second is integrity. As we know that our country is a conglomeration of various religious groups, various castes, colors and historical backgrounds. But this is a very cohesive unit. Unity in diversity is the sole motto of our Constitution. So at any cost, the integrity should not be compromised. Second is security of the state. Your freedom should not hinder or prevent or destroy the security of the country. Second, next is our relations with friendly states. As we know that countries have maintain relations with the foreign countries, and these are divided into two groups. One of them are friendly countries, the others are enemy countries. So right to freedom should not spoil our relations with our friendly countries. Order should be maintained. Decency. Your freedom should not do something which looks ugly, which is not decent. Your freedom should be applicable or should be used in a very decent manner. Next is contempt of the court. Your freedom should not violate the orders of the Supreme Court. Now come to the next part of this first heading, that is nature and scope. Scope of Article 19. Number 1. You must remember this, and I will ask question on this portion also. It is available to citizens only. So foreigners are excluded from this right. Secondly, companies and corporations are also excluded from this. You should note down this. In bank nationalization case, it is a very prominent case, and you should, to my opinion, you should prepare it thoroughly. In bank nationalization case 1971, Supreme Court gave an observation that this right is not available to the companies and corporations, but to the shareholders of the company. Second, in this regard, is the scope which includes is it incorporates not to speak also. You see, every right has two sides. One, it proposes something, and the other side restricts you. So, right to speak, it doesn't mean that you have a right to say something. but it also includes that you also own the right that you don't want. If you don't want to say something, no one can compel you. A very interesting case in this regard you must note down. I will mention two important cases. Number one is National Anthem case 1986. This was Bijoy versus Union of India. This case belongs to Kerala state. Now what happens is that in a school, when national anthem was going on, when in the morning after prayer, 2-3 students, they were not singing it. They stood up, they respected, they were not doing anything vulgar or to dishonor our anthem. They were just standing, but the thing was that they were not singing. On the basis of this, that they are not singing, the school authorities dismissed them from the school. The parents went to the Supreme Court, and so Supreme Court gave a very important verdict in this case, that right to speak also includes right to be silent. No one can, आपको कोई मजबूर नहीं कर सकता बोलने के लिए, आपको कोई जबरदस्ती बुलवा नहीं सकता, आपको फुल फ्रीडम है अपने ओपिनियंस एक्सप्रेस करने की, अपना विचार रखने की, बोलने की, क्रिटिसाइज करने की, बट जबरदस्ती आपके साथ ये कोई नहीं कर सकता है. सो राइट टू स्पीक incorporates right to be silent also. Then third is right to interview. This case is very interesting. I will cite one a very heinous case in this regard, that is known as Billaranga Case. See, briefly, Billaranga murdered two school-going brother and sister in Delhi. They raped the girl and later on they murdered it. So they were caught by the police. It's a long story, cutting it short. When they were brought in Tihar jail, some journalist from Hindustan Times, a political correspondent of Hindustan Times, wanted to interview them. So Tihar jail authorities, they refused to do so. A petition, PIL was filed in Supreme Court, and Supreme Court gave a verdict in this regard, that if somebody wants to be interviewed, no matter he is a criminal or normal citizens, you cannot prohibit to express the feelings or the opinions of even prisoners. So they were allowed to be interviewed by them. You should remember this thing, that right to express and right to speak is also available to the prisoners also. Next is freedom of press, as we know all. This is a very prominent, and so many cases in this regard came into Supreme Court regarding freedom of press. But I will not be going into the details since we have limited time. Freedom of express just means that before publication, you don't have to seek the permission of any authority before publication. Later on, curbs may be imposed, but previous sanctions are prohibited in these matters. So before publication of newspapers, they don't take sanction from any authorities. Next is right to information. This is a very crucial right given by Government of India in 2005. It simply means that all public officers are bound to supply the information asked by the common citizens of India. Okay, so the next is right to propagate. This also includes, if you belong to a particular caste, community, religion, or a thought, or any ideology, you have all rights to propagate your thoughts in the society to an extent that it is not harming the rights of other people. Okay? In this regard, a very prominent case can be mentioned here, that is telephone tapping case This case was simply, it was in 1997 case, Supreme Court case. The telephone tapping case was, it simply meant that government started tapping the telephones of some prominent people, and a case came into Supreme Court, and so Supreme Court prohibited this, that even conversation on telephone is a right to speak. It includes the right to speak, freedom of speech. So you cannot do this in exceptional circumstances. Now, we come to the third portion of this. As I mentioned, that Article 19(2) has given certain freedoms. What are those freedoms? Constitution guarantees us 6 freedoms in this tally. Number 1 is freedom of speech and expression, as I have already mentioned, that we have all rights to speak, express ourselves through different mediums. Second is to assemble peacefully. This should be noted down, and you can correlate it with the farmers' agitation in New Delhi, which is right now going on. We all citizens have a fundamental right to assemble in favor of our demands, but that assembly must be very peaceful. Number 1. Secondly, it must be unarmed also. It must not be instigative also. Third important freedom is to form associations. You know, we face so many associations in our life. Students have student associations, farmers have farmer associations, traders have their own associations, all sections have their own associations. So this right to form association is also covered under Article Speech and Expression, Article 19. Third is freedom of movement. You see, we belong to a free country and we are free citizens. We can move throughout our country without any restriction or prohibitions, unless some extraordinary circumstances arises. We have all freedom to go from one point to another point of our country. Residence and settlement is the 5th freedom which is granted by Article 19. We can build our house anywhere in any portion of the country except some conditions imposed by some states. The last is freedom of occupation, trade and business. See, this is very important freedom granted by right to freedom. No one can bound us to adopt a particular occupation, to start a particular business. We have full freedom to do any job, to start any business. And the second aspect of this is that, on the other hand, we have full freedom not to do any particular type of business. Means, इसका सीधा अर्थ ये है कि हम पूर्ण रूप से स्वतंत्र हैं किसी भी काम, किसी भी ऑक्यूपेशन को अडॉप्ट करने में, और किसी भी काम और ऑक्यूपेशन को छोड़ने के लिए भी. Okay. Now, this is all about Article 19. You must carefully prepare it, and I will be asking some questions on this. Now, let us move to next article, that is Article 20. As I mentioned that right to freedom includes from articles from 19 to 22. The next article in the line is Article 20. This is there are some very peculiar things about this article which we must note down. First is, this article is available, as I told you, to citizens as well as non-citizens also. Okay, the very interesting thing about this article is that this article cannot be suspended even during emergency, national emergency. This is very peculiar and interesting aspect of this article. So, but this is what this Article 20 says. It says that you cannot convict arbitrarily, you cannot grant punishment arbitrarily, and even convicted people have their rights. Now, again, we can give a heading to this article also, that nature and scope, as we did in the previous article. Nature and scope, nature, that as I told you already, that nature means that this article is very permanent nature, it cannot be even suspended during emergency. Then what is the scope? Scope, it includes citizens, foreigners and corporations also. Okay, as we saw in AK Gopalan versus State of Madras, that the 19 was not available to corporations. This article is also available to foreigners and corporations also. This is applicable only in criminal cases. Criminal cases. Now, there are three basic provisions in this article. One, it deals with Article 21. It clearly mentions that, one heading you must note down, ex post facto laws. It simply means no law can be implemented in this regard prospectively. पहले से अगर ऑफेंस पहले हुआ है तो नया लॉ उसके ऊपर लागू नहीं हो सकता है, इसका सिंपल मतलब ये है. I can give you one example to simplify this, that if someone commits a crime today and there is no punishment mentioned in our constitution regarding that crime, but during the process of trial some new law comes into existence for the same punishment, then that person cannot be punished under that new law, because when he committed that crime there was no such law. Okay, agar कानून नहीं तो punishment नहीं, it simply means. Second important thing is that अगर कानून आता भी है in this regard, तो पनिशमेंट अगर पहले कानून से अधिक है तो वो उस पर लागू नहीं हो सकता, मगर अगर नए कानून की पनिशमेंट कम है प्रीवियस कानून से तो वो उसके ऊपर लागू किया जा सकता है. सो कमी में तो ये आर्टिकल लागू हो सकता है मगर अधिक पनिशमेंट में नहीं हो सकता. सेकंड इज 20 point provision 2, protection against double jeopardy. It simply means that one person cannot punished twice for the same crime. एक ही क्राइम के लिए एक व्यक्ति को दो सजाएं नहीं हो सकती हैं. Third important criteria in this is, prohibition against self-incrimination. What does it mean? It simply means that the accused cannot be produced in the same case as a witness. If someone has committed some crime, तो पुलिस और जुडिशरी के सामने उसी व्यक्ति, सेम व्यक्ति को एज ए विटनेस प्रूव नहीं किया जा सकता, वो खुद का अपना विटनेस नहीं दे सकता. ओके, सो दीज आर today we dealt with Article 19 and 20 in some briefly. I will now move to some important questions which you should note down. The first question in this regard is, explain briefly the 6 freedoms mentioned in right to freedom. We discussed right now. First question is, explain briefly 6 freedoms mentioned in right to freedom. Next question is, write a note on reasonable restrictions imposed in Article 20. The third important question is, a brief note, prepare a brief note on RTI, Right to Information Act. Fourth question is, what are various grounds of restrictions on freedom of speech? What are the various grounds on, what are the various restrictions on freedom of speech. This is all about today. Thank you very much.